Sikshayati, platform for eminent authors, engaging teachers, successful students. To know more, email. Mistake. Mistake means something wrong done unintentionally. Mistake is some unintentional act, omission or error arising from ignorance, forgetfulness, etc. Types of mistake. Mistake may be broadly categorized as follows. Mistake of law of land. Everyone must be aware of the law of land. One cannot plead ignorance of any law of the land. Ignorance of law is no excuse. Ignorentia Jures non excusat. Contract valid. So a contract is valid even if any of the party has committed mistake being ignorant of some law of the land. Example, X and Y made a contract on erroneous belief that a particular debt is time-barred by Indian law of contract. The contract is valid and not voidable. Mistake of fact. Mistake of fact arises when either or both parties are under a mistake of foreign law or mistake of a fact essential to the agreement. Bilateral mistake of fact. Bilateral mistake arises when both parties make mutual mistake to a matter of fact essential to the agreement. Mistake of in foreign law is also treated like bilateral mistake of fact. Example, A sold some land to B. At the time of sale, both parties believed in good faith that the area of the land sold was 10 hectares. It, however, turned out that the area was 7 hectares only. It is a case of bilateral mistake and the agreement is void. Types of bilateral mistakes. Bilateral mistake as to the subject matter. Where both the parties to an agreement make mistake relating to the subject matter, that is existence, identity, quantity of, quality of, title, ownership of, price of. These are subject matters. Example, X had 2 cows, one black and another white. X offered to sell the black cow to Y at rupees 20,000. Y agreed to purchase the cow, believing that X is selling his white cow. Hence, there is no contract as there was bilateral mistake on the subject matter. Bilateral mistake as to impossibility of performance. If both the parties believe that the contract is capable of being performed, but in real condition it is impossible to perform, the contract is void on the ground of impossibility of performance. Example, A, an engineer, agreed to make a machine to supply B. None of the parties A or B knew that such machine will not perform with currently available technology. The contract is void. Agreement void. The agreement under bilateral mistake is void. However, an erroneous opinion as to value of a thing is not considered as mistake of fact. Unilateral mistake. Unilateral mistake arises when only one party is mistaken. Contract arising out of unilateral mistake is neither void nor voidable unless it is brought about by the other party's fraud or misrepresentation. Example: A contracted with B for the erection of several houses. In calculating his price for the houses, A by mistake deducted a particular sum twice over. B signed the contract which correctly represented its intention. It is unilateral mistake with no intention to fraud or misrepresentation. Hence, the contract is valid. Example: A picks up a piece of imitation jewelry from jewelry shop who sells gold and imitation jewelry and buys thinking it is of real gold. The contract is valid and the buyer cannot demand to return the jewelry bought. However, if the shopkeeper sells by fraud telling it as gold jewelry, the contract is voidable. Fundamental in unilateral mistake. Sometimes a consent is given under a fundamental mistake going into the root of the agreement. Though normally a unilateral mistake cannot be considered as a defense to avoid a contract, if the consent is given under a fundamental mistake going into the root of the agreement, such unilateral mistake as shown in the following cases makes the contract void. Mistake in the identity of the person contracted with. Mistake in the identity of the person contracted with. If the identity of the party is essential and important to the contract and not other attribute of that person. Example: B places order for various stationery supplies to S, his usual supplier. Unknown to B, S had sold his business to T. T sends the stationery to B. B, upon discovering the facts, refuses to accept the stationery. T must take back the stationery as there is no contract between T and B. B never intended to enter into a contract with T. Mistake in nature of contract. Mistake in nature of contract when there is mistake is in essence of the contract. A, an old man of feeble sight, signed a bill of exchange thinking it was a guarantee. The contract is void because the mistake is of essential fact. Thank you for watching the video. Kindly write your comments. Click on the red subscribe button at the bottom of the video to get more details and free ebook. Email us.